Dear friends, uh, let us get into the introduction of contract law. As you understand, contracts play a very critical part in our day-to-day activities. Be it contracts of implied nature. When I say implied, it means that it happens. You may be probably hiring an auto rickshaw or a bus, and many of these contracts are implied in nature. And then there are contracts that are explicit, which have a formal documentation of what has been agreed, say buying of immovable property. And hence, contracts being an integral part of our day-to-day activity, the law that governs this relationship becomes a very important point of understanding. Why? It is because probably, friends, you will understand that the kind of challenges that contracts give rise to have also given rise to numerous disputes. These disputes, you will notice, finally land up either through arbitration or in the courts. And because of contractual disputes, either you have a good business or you would have bad business. I often say this, that a good contract results in good business, whereas a bad contract results in bad business. So we will understand the rules of contract law. And please note, while you look up it in India, we go to a federal law or a central law called the Indian Contract Act 1872. Please note, it is 1872, not 1972. It's a British-made law. And we look at it as a uniform law for the whole of India, including to Jammu and Kashmir right now as we speak today. And the Britishers said that this is a uniform law which will actually promote commercial transactions. Now, commercial transactions are, are the basic, market forces of an economy. And hence, if you have a robust contract law, it gives kind of a confidence for a robust commercial and business relationship. And hence, the foundation of all business is kind of a law that actually promotes, protects their business relationship, and contract law actually tries to do the same. Friends, let me introduce you to the books that we have authored and which can be useful for further references and readings while we understand contract law in this course. The first book is published by the National Law School of India University. It's titled Contracts, Agreements and Public Policy in India. We call it the NLS Book Series 1. This has some very interesting articles on modern forms of contract. It has included different aspects of development that the courts have actually contributed in understanding and interpreting contract law. So this is a very interesting book that you should get to read to understand contract law much better. The Sage Law book on law of business contract is also very interesting. You can also get this book. This has some modern kinds of contracts like joint ventures and franchisee contracts, and you will notice that the legal development of the same becomes very important for us to look at contract law in the current context, especially as we talk about the challenges of globalization of contract law. There's another book that has been published by Eastern Law House. It is on privatization and globalization. You will notice that this is an era that has brought in a lot of multinational dimensions to contract law. You talk about international principles of contract law. Arbitration has moved away from India, and hence there is influence of other comparative contract law jurisdictions, especially the American, the common law, that is the United Kingdom. Some principles from Singapore are also influencing contract law as we speak today. So you can get hold of this book to understand the impact of privatization and globalization to Indian businesses in this book published by Eastern Law House. If you want to look at specialized contracts, especially in the energy sector, for example, we talk about power purchase agreements, and the energy sector is the sector that is actually booming. It's a sector that has a lot of opportunities, both in the renewable sector right now, as we speak about, in terms of solar, in terms of wind, and so on and so forth. There is a lot of emphasis on renewable sector because of climate change and other policies. You will notice the entire law and policy on that is available in this book. But look at the non-renewables as well, including coal and other fossil fuels that have been contributing to energy and power. You will notice the production, the distribution of the same, all is through contracts. And contracts play that kind of important role in the dimension of energy policy in this country. And we are talking about a kind of privatization of the energy sector post the Electricity Act of 2003. We have talked about the regulator that has come into place that may actually look at contracts in the energy sector. That's very interesting. So if you look at the powers of the Central Electricity Regulatory Commission, they can actually look at contracts in the energy sector. They can actually moderate the prices in the energy sector. And we have some very interesting cases from the energy sector that we'll discuss in contract law. So this book can also be an additional useful tool for you. Finally, coming to public-private partnership, friends, you will notice that this is the mantra kind of in government contracts right now. The government does not want to entirely privatize because there are a lot of risks involved in entire privatization. We are a welfare state, we are a socialistic model, at least in the benchmark of grassroots policy and developmental debate. And hence, the PPP model has become an entire model of doing contracts and businesses. We know that the government holds a great amount of opportunity for business and contracts, and hence government contract has received a whole new dimension through public-private partnership. The last book that you see on the slide is a book that actually gives you a fantastic introduction to the model or the history of PPP, the current model on PPP, and the development into EPC contracts. Because you will notice engineering, procurement, and construction contract is probably also one of the methods that the government now adopts in its model. Now, where do you see PPP? Friends, you will see PPP in so many sectors, right? From the airports to the highways to the defense to even the railways. I think the public-private partnership model is an interesting model. And let me tell you, the bedrock of a PPP is a contract, right? Everything happens through the contract model. They are long-term concession agreements, and hence there are a lot of implications of how this can be looked into. Let's move on to understanding the different aspects of contract law. In case any of you would want to get hold of understanding of the law, then I would suggest that you can look at the Indian Contract Act 1872. You can keep a bare act of the same, or you can download it online. It is the foundation law, it is the mother law in understanding which is a valid contract and what is an enforceable contract, right? And some of the contracts you will notice in India are not going to be enforced by the courts of law. There are strict regulations of which contracts are acceptable and which contracts are not acceptable. So understanding the entire law becomes critical, and hence this is the first law that we will take into consideration. Now, the Indian contract law does have certain remedies for breach of contract. So if the parties do not fulfill their promises, if they don't fulfill their obligations, there is a penalty, there is a liability. Right, so I think you cannot get away with the law. You cannot get away with contractual obligations simply like that. So the law imposes some kind of obligations if the party fails to honor the contract. And hence, while damages are one of the remedies that are looked in the law of contract, there are several other remedies that are also available to the parties, and those are mentioned in the Specific Relief Act of 1963. It has been amended in 2018. We will talk about that amendment as well. So if you talk about what courts can do in case a contract is breached, what is the function of the court and how do they remedy the relief that the parties require for breach, I think the Specific Relief Act is a very important legislation for us to refer as well. We should also look at the Indian Partnership Act. 1932, it's a form of business. You know, partnership is a very integral form of business. But remember, in India, we have two laws on partnership. One is the Limited Liability Partnership Act of 2008. It's a recent law. It's mostly part of business and corporate law. You can actually establish this model of limited liability partnership. You don't have to form a company and you can run a business. But the earliest form of doing business was probably the Indian Partnership Act of 1932, again, a law during British times. And while the Britishers said that, look, one man's resources, both manpower or finance, may not be sufficient to propel the economy and the business. So two or more people should come together. They should put in their human resources, they should put in their capital, and they should actually start doing business in India. So when two or more, from there probably you go to a joint stock company and you create a public limited company as well. The partnership model is a model of business. However, you will notice that when two or more persons come together and they want to do business, the bedrock of this kind of a business becomes a contract. Right? Contract, or what we call as the partnership deed, is the basis on which the two or more people who decide to form a partnership actually go about their business. And hence, there is a strong linkage of contracts even for formation of a business and even for running of a business. And that, I think, we could definitely understand by discussing the partnership law. The fourth law that should be useful for us is the Information Technology Act of 2000. Friends, you will notice this law was also amended in 2008. Why should we refer to this legislation? Is because we are talking about modern forms of contracts, which we call as electronic contracts or digital contracts or contracts in the internet world. Now, this is now increasing, isn't it? Most of us are actually ordering online, we are booking online, everything is online, right? From hotels to flights to trains, even food or grocery, everything has moved to the digital space, and internet is widely used for contract making. I think you will notice while the Indian contract law encompasses all kinds of contract, right? You will notice it is a good law. It has withstood the test of times. However, the aspects of information technology law, which governs internet and commercial transactions, or what we call as e-commerce transaction, is also very important. There are a couple of sections in this law that are very critical for our understanding of contract, including section 10A. We should refer to this law to actually look into e-contracts. Final law that may be of relevance currently as we speak today is the Sale of Goods Act, and this was a law that was brought about in 1930. It is a special law that deals with goods or commodities or material that are kept on sale. We know that there are two kinds of sales that can take place. One is of mobile property, the other is of immobile property. And goods which are part of the mobile property law are covered under a separate legislation. So the Sale of Goods Act interestingly gives you the dimension of what can be a warranty, right? When does sale actually take place? This is interesting. Some of you may also understand what is INCO terms, that is called international commercial terms. And some of these aspects are covered under this law. So it's a complementary law, it's a special law because it talks about even special remedies for sale of goods. There are special rights to the parties, especially to the sellers and the buyers. The aspect of auction sale for the first time gets defined under this law, and hence this law adds a lot to our understanding of contracts.